Okay, well, we've got one final topic for everybody. Thanks for hanging in. My name is Rebecca Stevens. I'm a partner in the employment practice.
And I'm Jaya Narang. You hear me?
Yeah.
I'm Jaya Narang. I'm a senior associate in the employment practice.
And our last topic for today is about pay transparency laws, another hot topic that is getting lots of discussion nationwide. So here's our agenda today. We'll provide a little bit of an overview. We'll cover the California requirements on a number of topics. We'll touch briefly on what's going on in other jurisdictions. We've got some example salary postings for those who are wondering what other employers are doing. Suggestions for mitigating risk for employers that operate in multiple jurisdictions. Some advice regarding pay equity audits, and then finally looking ahead to what's next, what's coming down the pike, we think, in state and nationwide.
So it may or may not come as a surprise that there are still persistent pay gaps in the United States. As of 2024, women were still only making 84 cents per every dollar earned by a man. Women still earn less overall in more than 90% of occupations, even those commonly held by women. And these disparities are even more prevalent when looking at minority, racial, and ethnic groups compared to white men. Pay transparency laws are designed to reduce these disparities. So new legislation is being passed throughout the United States to require employers to provide more open information about compensation to employees and candidates. In California, this has cropped up in the form of several newer legal requirements, including disclosing salary ranges and requiring reporting on pay, all of which we'll cover in some more detail.
Great. So one of the ways in which the legislature has decided to increase transparency around pay is through salary postings. So this was actually passed in 2023. So hopefully you're already aware of this requirement. But Senate Bill 1162 requires employers to disclose pay scales on job postings for any position that might be filled in California. And notably, this actually applies to employers that are not based in California, but might be hiring California workers for a remote role. So it's very broad. The definition of pay scale under the statute is actually fairly narrow and only includes the salary or the hourly wage range that the employer reasonably expects to pay. This information has to be in the job posting itself. It cannot be provided through a separate link or a QR code. So at first, I think it was kind of popular for employers to say, you can click on this link and find out more about our pay practices. That's not permissible under the statute. It's got to be right there in writing. Currently, under California law, these postings do not need to include bonuses, benefits, or perks such as paid time off or other compensation. But as we'll get to in a few minutes, other jurisdictions are requiring that information. And there are penalties up to $10,000 for failing to comply. This is assessed by the labor commissioner on a case-by-case basis based on the totality of the circumstances, but one of the factors is whether the employer previously violated the statute. In addition to posting the pay range for position in the job posting, there's also a requirement that employers provide employees with the pay scale for their position upon request. So if you've got an employee that's been employed for a while, maybe they've already been hired into the role and they've been promoted to a different role, or they've transferred, or some time has passed, those current employees are actually permitted to request the pay scale for their current position. This definitely results in some awkward issues in the workplace, which we'll cover at the end of the presentation. You are not required to disclose the pay scale for other positions, such as their manager or their peers, or positions that they're not currently in. But obviously, because of these job posting requirements, sometimes employees can discern that information from those postings. And so it does create some awkwardness and tension when people start raising concerns about perceived disparities. And the pay scale definition here is the same as under the job posting requirement, which is just the salary or the hourly range that the employer reasonably expects to pay, does not include bonuses and other forms of compensation. And as noted, there's this penalty of up to $10,000 per violation. There's also a rebuttable presumption in favor of the employee if the employer fails to maintain records of the employee's job title and pay rate history for a specified time frame. So keep that in mind.
So this is another requirement that's been around for a while, so hopefully you're already aware of it. But since January 2018, California has prohibited employers from seeking a candidate's salary history. This includes directly asking the candidate for their salary history or indirectly through a recruiter or headhunter, for example. Applicants can still, without any prompting from the employer, voluntarily provide their salary history, but employers are still prohibited from relying on that salary history to justify a pay difference between that employee or that candidate or an employee of the opposite sex. This can be a fine line and can get tricky. So the best practice is to not rely on a candidate's salary history when determining an applicant's potential salary. California also has pay data reporting requirements. Employers with more than 100 employees are required to annually report pay data on each of 10 specified job categories to the California Department of Fair Employment and Housing. This includes all employers with 100 employees, with any employees in California, even if it's just one employee in California. The reports also should include remote employees if they're assigned to a California establishment. And there should be a separate report for each establishment in California that the employer may have. The report is required to include the race, ethnicity, and sex of employees in the 10 specified job categories and broken out by various pay bands. Also, within each of those job categories, the employee must include the median and mean hourly rate. And this should all be in the form of a snapshot of a W-2 earning from a single pay period from the prior calendar year between October and December of that prior calendar year. I know it's small on the screen, but this is an example of what the reporting requirements look like. This is one of the specified job categories. So as I mentioned, the employee's pay data are based on a snapshot of a W-2 earning from the prior calendar year. The report breaks out the number of employees by race, ethnicity, and sex in those various job categories and reports each of those employees by race, ethnicity, and sex as they fall within the pay bands. These pay bands have been prescribed by the Bureau of Labor Statistics. Significantly, as you will see at the bottom of the report, the pay data report must also include the median and mean hourly pay rate for each combination of race, ethnicity, and sex, and for each job category. So these reports are currently not subject to public disclosure via the Public Records Act, but the legislature is considering changing this, so these soon may become publicly available. And there can be significant penalties for employers who fail to comply with the reporting requirements. It starts at $100 per employee for a violation, and it goes up to $200 per employee for subsequent violations.
Okay, so we won't spend too much time covering other jurisdictions, but we're kind of providing these slides just to show you that these issues are not just specific to California, they're cropping up everywhere. And the challenge is that every jurisdiction has slightly different requirements for these wage disclosure provisions that are in the law. So as noted before, California is only required to provide the base salary and the hourly pay that's reasonably expected for a position. But as you'll see, as we kind of scroll through some of these other jurisdictions, some of them require more detail. So some of them require disclosure of benefits, some require disclosure of bonuses, stock, other incentives, tips, commissions, things like that. So for employers that are recruiting nationwide or have nationwide operations, it's obviously very challenging to satisfy all of these rules with a single job posting.
So again, in the interest of time, we're not going to go through all of these, but as you can see from this list, there are a lot of states, in addition to California, that have implemented salary history bans. These laws are continually changing, so it's possible that this list just continues to grow. As of now, there are less pay data reporting requirements nationally in other jurisdictions, but as an example, Illinois has gone one step even further than California and is requiring covered employers to submit employee level pay data to the Illinois Department of Labor. So what that means is they're required to submit detailed information about each employee's individual pay and identity. They've also made aggregate pay data publicly available and have passed legislation similar to the one in California, allowing employees to request anonymized pay data from their employer about their own job categories. In addition, the EEO-1 report, which the government is already collecting each year from covered employers, has a form known as Component 2 that consists of pay data reporting. That is not currently being collected, but it seems likely that that will change, especially considering that the form is already available.
So a question that we always get when these new laws come out is, what are other employers doing? And so we thought we'd show you a few examples. These are just job postings that we found online. These are publicly available. These are not our clients, and we will not tell you the name of the employer, but we'll show you some examples. So here's one, very broad, as you'll see at the bottom. The range for this position is $230,000 to $960,000, which is incredible. I mean, if I was hired for this position, I'd probably try to negotiate for that top end. It sounds pretty good. Notably under California law, there's nothing that would prevent a range that is this wide yet, but there has been, certainly online and on these kind of employee forums like Glassdoor and other places, a lot of online criticism of employers who have ranges that are this broad that don't really give a lot of information that's specific to the position. And I suspect that at some point in the future, there might be some more crackdown on things like this that don't really comply with the spirit of the law because it's just so broad.
This is a direct opposite of the example Rebecca just showed. Here's an example of a very detailed salary posting. The base pay range here is listed as $206,700 to $289,400. So the pay range provided is much more narrow, and there's more detail in the posting provided about the general compensation structure and that company's pay transparency philosophy. So it seems, likely that the more broad salary postings might be challenged in the future. So it might be a good idea to provide more targeted and specific salary postings.
Another thing we've seen pretty commonly from multi-jurisdictional employers is that they'll provide different pay scales for different locations. So as you can see in this example, this top one, there's an overall range. There's a range that applies to Seattle and Washington, D.C., where they have offices. They are pretty clear about, based on your location, you may be paid differently. That is certainly permissible under applicable law. And then similarly, in that second example, you'll see it broken down by different jurisdictions as well. One thing I did want to add is that while Jaya and I were looking for examples online, we found many, many job postings that still do not contain the wage range and are recruiting in California and other locations where it's required. So I think that's kind of a bit of a ticking time bomb for those employers, because it's the kind of thing that the government agencies would view as sort of low-hanging fruit. It's pretty easy to reach out to that employer and say, hey, you're not complying. Now we're entitled to recover a penalty from you.
And that's especially tricky for employers who are recruiting nationally for remote employees. These requirements still do apply.
So in terms of risk mitigation, a few key takeaways for employers that are operating in multiple jurisdictions: obviously developing pay scales for all the positions and auditing those pay scales for equity issues. That's a topic we'll cover in just a minute. Make sure that you're frequently reviewing job postings for compliance with state and local pay disclosure requirements. We've been focusing on California, but as noted, other jurisdictions have other requirements, often more stringent than California. So you need to kind of make sure you're complying in those places. Again, with the pay equity audits, periodically reviewing compensation skills and practices for equity, risk, and compliance issues. Conducting pay equity audits under the advice of counsel, which we'll turn to momentarily. And then, of course, training is a consistent theme with everyone today, but training HR managers and personnel who are involved in hiring regarding compensation, interviewing, and best practices.
So just by a show of hands, how many people in the room know that their companies are regularly conducting pay equity audits?
And for those who don't know, a pay equity audit basically means kind of gathering data about the pay of all of your employees demographic information about, how they're leveled within the company, and then evaluating potential disparate impact or disparate outcomes based on different demographics. So looking at, are we seeing significant differentials within the same types of jobs based on gender or race or other factors that would be protected under the law, in which case we may need to do some more digging to see if we think those disparities or differences are justified or if they are creating legal risk, and then potentially taking steps to address that. So if anyone in the room is working on those kinds of things, or anyone online, I think there's a poll that came up as well. Okay, so online it looks like it's a little less than half of our audience is conducting these, and then didn't see any hands in the room, so maybe people are just being shy.
Pay equity audits can be very important in this new era of pay transparency. Consider a company that has a long history of not discussing salaries internally. In response to these new California laws, they're suddenly having to post salary ranges on their job postings. Now, if employees ask about the pay range for their positions, they're required to provide those pay ranges. And if this company wasn't already auditing pay, this new transparency could easily result in employees discovering that their colleagues or potential applicants who'll be working the same jobs as them are actually earning significantly more than them. Sometimes this is explainable, but without information about these potential pay disparities, it can be difficult to explain away those inequities and have discussions about salary.
And I'll just add, I've been asked to advise on a lot of issues that have come up in response to these kinds of pay disclosure requirements. I've seen, employees asking for the pay scale for their position and then realizing that their salary is at the very bottom. And then they escalate to their manager. Why am I at the bottom of the pay scale? Whether or not there's a real legal claim there, there's obvious morale issues and employee relations issues. Or, somebody requests the pay scale for their position and then they share it with the rest of the team and everybody starts comparing where they each fall. And those kinds of discussions then bubble up to human resources or management. Why is this person getting paid more than me? I started here before they did, those types of questions. It can be very awkward to have to respond to those kinds of inquiries. And ideally, if you're conducting these kinds of pay equity audits in advance, you're prepared for those types of responses. I can't discuss so-and-so's compensation with you due to confidentiality and privacy requirements, but here's more information about our philosophy. We take into account things like experience, education, those types of things that may be relevant. But if you are in the position of having to tell an employee, well, this is our philosophy, and they come back and say, yeah, I have more experience, more education, I've been here longer, and I'm still getting paid less, you don't want to find yourself flat-footed in that situation.
Yeah, and for all the reasons Rebecca just described, pay equity audits are an important tool for a company to identify its own vulnerabilities and be prepared before these pay transparency laws reveal inequities the hard way. So when conducting these audits, just a reminder, we always advise that they're done through careful collaboration with legal counsel. This is very important to maintain the privilege of those analyses to the extent possible.
Yeah, and just to elaborate a little more on the privilege piece, a lot of employers take the position that the entire audit and all of the underlying information and all of the data is privileged and confidential and can't be disclosed. I think the courts are pretty clear that there's a distinction between the underlying data, which of course is discoverable through normal civil litigation processes, but certainly any communications with counsel about, hey, we're seeing some risk in this department, we're seeing some potential inequities, let's dive deeper into that. Any discussions about should we adjust this person's compensation because we're seeing some risk in this area, those communications should be privileged and confidential, while the underlying data would typically not be. That being said, you want to be very, very careful about who that information is shared with, who's involved in those discussions, to make sure there's not an argument somewhere down the line that the privilege has been waived because people sort of outside that context are getting access to those considerations. Okay, so looking ahead to what's next, California is typically a leader on new legislation protecting employees. That being said, there are a few things that have cropped up in other jurisdictions that California has not yet adopted, but may provide a little bit of a preview for what's coming to us. So in Colorado and Illinois, there are now some interesting requirements where employers have to disclose, in addition to pay scales and pay bonuses and things like that, information about career progression and promotion requirements. Some of that is just whenever you post a position externally, you also need to notify all employees internally that there's a promotion opportunity for them. So it's not just being disclosed to external candidates, but internal employees know, hey, there's this position open that I might be able to be promoted into. So that's kind of an interesting aspect. And then similarly, disclosure in detail as to what is expected and an expected time frame for promotion in certain roles. I found that pretty interesting because, as most people in this room can appreciate, employers don't often anticipate, when you're hiring for a particular position, like what's the promotion opportunities for this person and what would they need to do, 3 years from now to get promoted. So that seems like a bit of a difficult scenario to grapple with. Some jurisdictions, such as New York, are now requiring very detailed job descriptions in their postings. So in addition to disclosing information about the pay, disclosing lots of information about the specific expectations of the role, what that person is going to be doing. You could see how this could come up in other contexts, for example, where, in accommodation cases, somebody refers back and says, hey, this was not included in my initial job description. And now you're saying that is something that's an essential function of my position and preventing me from being accommodated. Or you can see some of those breach of contract claims that Chandra and Ben were referring to in the last presentation. If somebody says, these were not the duties that were in the job posting when I applied, and now you're telling me that I have to do these duties. So seems like it's an area that could be ripe for conflict. Similarly, I think California will eventually likely follow suit and require more details about bonuses, equity, and other forms of compensation. Right now, they're kind of bare bones with salary and hourly rate, but those other jurisdictions are requiring so much more detail that I suspect California will eventually follow suit. And then lastly, as Jaya noted, those pay data reports that are going to government agencies, I do suspect that at some point, more states will adopt pay data reporting requirements and also make those reports publicly accessible, like Illinois has done. I used to, before I came to Farella, practice on the plaintiff side and recall being at a plaintiff's employment conference where the plaintiff's attorneys were talking about how easy it is to just go ahead and request the EEO-1 report for an employer through the EEOC through a FOIA request, and then go in there and identify any perceived discrepancies or differentials, and then file a class action lawsuit based solely on that report. Just find an employee and file a lawsuit. And so I do think, there might be pressure from the plaintiff's bar to make those kinds of reports more widely available, to allow that type of filing. And just in general, with this trend towards being more transparent about people's pay, I do think those reports will eventually become more widely available. So that is it for our substantive presentation. If anyone has any questions, we would be happy to answer them.